Hello, everyone. Welcome back to my YouTube channel with your host, Kensani, and we bring you all things legal wisdom and insightful content. With me today, I have Mmamphai Makgabutlane, and she is an admitted attorney of the High Court and managing director at Sambo and Makgabutlane Attorneys. Welcome, Sisi.
Hi, Kenzie. Thank you for having me, and hi, everyone at home.
Yes, it's a pleasure. I was just saying I'm so inspired by your work and how you are a entire managing director, guys, at such a young age. And yeah, please tell us a bit about yourself, where you studied, and why you decided to start a law firm.
Okay, I'm born and bred in Pretoria. I did my LLB with the University of South Africa, and immediately thereafter, I did my PhD, not my law school rather, with Lead, where they give you like a kind of like a theory on what law practice is all it's like. Thereafter, I got articles with a very big law firm in South Africa that does pro bono cases. So I did that for a good 2 years. And then afterwards, when my contract was expiring, I was left with an option. Do I go and seek employment, or do I go into practice, or not, or open my own firm? At the time, it's a very big decision. It's very intimidating. So I was lucky enough to have a partner who was like, you know what, let's do this. Let's start a law firm. We're still young, and we can take on this profession and give it a new twist, or twist, if I should use that word. So we started it, Sambo Makgabutlane Attorneys, and I'm the managing director and co-founding partner.
Awesome, awesome. It is a big decision. I mean, most youngsters like me, we're so risk averse. Like, I wouldn't risk it to just start a law firm after articles, and you did it. Congratulations.
Thank you so much.
I went through your website to also just see what you guys do and what your goal is, and I saw that you speak of not just justice but also socio-economic justice, or redressing the imbalances of the past. And I wanted to just find out what that means to you and what it looks like.
As I stated earlier on, I did my articles with a law firm that did pro bono matters. So now I got to deal with people who could not afford to get legal assistance. So now you find that there are people who do have money and those that don't, but they can go to pro bono law firms to get assistance. But then there's that middle ground where people they don't qualify for pro bono, but they don't qualify for an attorney. So it's like, okay, you know what? Let's create a law firm that can cater to those people, so that justice should not be for people who have money, but it should reach everyone, because as the constitution says, it covers everybody. Everybody is equal before the law. So it should not be that, no, because this person can't afford to, then their rights are limited because of that. So that's what we're trying to do here at Sambo and Makgabutlane Attorneys. Just try to assist people, give them access to quality legal assistance, and that is affordable. And
Awesome, awesome. I like that. So, what do you guys do at Sambo Makgabutlane Attorneys?
well, we do family law, divorces, we do criminal law, estates, as well as civil and contract law.
Okay.
So we're mostly criminal and civil law.
Okay.
Yeah.
All right. I think we'll just get straight into, excuse me, the main aim of the video, and we are going to discuss your areas of practice, i.e., family law, and maybe crim if we do get the chance. So I thought we should start by quoting or reading from a constitutional court judgment that's just going to help us flow into our conversation. The institutions of marriage and the family are important social institutions that provide for the security, support, and companionship of members of our society and bear an important role in the rearing of children. The celebration of a marriage gives rise to moral and legal obligations, particularly the reciprocal duty of support placed upon spouses and their joint responsibility for supporting and raising children born of the marriage. These legal obligations perform an important social function. This importance is symbolically acknowledged in part by the fact that marriage is celebrated generally in a public ceremony, often before family and close friends. The importance of the family unit for society is recognized in the international human rights instruments referred to previously in the case when they state that the family is the natural and fundamental unit of our society. So, from there we see different aspects of family law coming into play, and from custody to actually the rearing of children, and how marriage has legal obligations and moral obligations, and as well as a reciprocal duty of support. So I think my first question with regards to what we just read surrounds custody of children. When parents undergo a divorce, it really affects the children. And then the issue of custody comes into play. And then you find that the other parent is trying to blame the other parent and say that, oh, she smokes, he drinks, he can't take care of the children. What do the courts consider when a matter is brought before them for custody?
That is actually a very good question. What people need to note is that when spouses are divorcing or separating, it doesn't mean that they're separating from their children. So when we're dealing with divorce matters, the interests of the children are of paramount importance. So we look at the best interests of the child. So to do that, usually we seek assistance from the family advocate to come and assist the parents if there is a dispute regarding the parental rights and who's going to be residing with the kids, and also right of contact with the children. So the family advocate in that instance will come on board and assist the spouses in drafting a parental plan, which will take into account the parents' wants and needs, but also what the child needs as well. Because we cannot only be focusing on what the parents want, we must also listen to the children and take their view of the situation into consideration. So when we're dealing with divorce matters, we always look at the best interest of the child, so that because already the family unit is going to be broken, so we don't want the child to suffer even more than they need to. So it's a very delicate process, but we need the assistance of the family advocate, of counselors, to come in and to assist, especially when there's a dispute. Many of the times you'll find that the parents are like, you know what, we understand that it's us who are breaking up, but we want our children to still be in both our lives. So in that instance, then we just draft a parental plan, and then we take it to the family advocate to review it and say, okay, fine, we're happy with it. The children's needs and interests are considered, and they usually endorse it. Then we can take it to court to make it a formal court order.
Shucks, that's so good. From what you said, I heard you say that when parents are separating, that doesn't mean they separate from the children.
Yes.
So I thought we should just highlight that again for whoever is going to be watching the video. Also, there's legal obligations that come from a marriage, depending on the type of marital system you are going to select. Usually we hear people speaking of the default system and the consequences from there. So can you explain to us what that is? What are the marital consequences? What are the consequences of all the marital systems that we find in South Africa?
Oh, well, in South Africa, we have three, if I should say, main types of marriages. Civil marriages, in terms of the Marriages Act. Those are the ones that I'm going to be talking about now. We have marriage, which is in community of property. And then we have marriage that is out of community of property altogether. And we also have marriage out of community of property, including the accrual system. With marriage in community of property, basically it means that everything is shared. We talk about a joint estate, meaning everything is 50-50. we share 50% in the assets and also 50% in the expenses of the
Sure.
estate.
So good.
So we're talking about a joint estate when we speak of marriages in community of property. And marriages out of community of property without the accrual system, basically you leave with whatever you came with. So if you came with a shed, that's what you're taking at divorce, That's what you're leaving with. So there's complete separation. There's no joint estate, nothing of that sort. Now, the nice middle ground we find in marriages out of community of property, but with the accrual system. In that type of marriage system, basically it is out of community of property. However, when the marriages end, either by divorce or by death, then we look at, okay, fine, since the beginning of the marriage and the end, how has the different estate of both parties grown? And then we look, and the person who has a higher estate, value of estate, then they have to share half of the earnings with the one who has a lesser estate. So that is a system which requires some calculation to determine, okay, fine, who must get the accrual and who must not. But with all of those marriages, obviously there's a duty, an obligation that comes out of entering into that marriage. Because remember, ultimately marriage is a contract. Okay. Indeed. So you had mentioned the duty of support in that. That duty is basically not, I would say that it's discretionary.
Okay.
Because when we look at a duty of support, we look at number one, is that person who you are seeking support from able to provide that support? And then what kind of support that person needs. So it usually, when we're at court and considering issues of maintenance of such things, then we look at it, fine, is that person able to provide maintenance? Can they afford it? And why do you say you want maintenance? And then in that way, the court will take its discretion and kind of find a reasonable balance in order to accommodate both parties. Yeah.
Okay. All right. So if I undergo divorce and I had somebody providing for me, and let's say I was not employed, but I was taking care of the children or taking care of the household and maybe a part of a small business that my partner had, am I entitled to some form of support if I was not working?
With divorce matters, we look at the kind of lifestyles that you were living. Because now, what we use with divorce matters, we talk about the clean break principle. Meaning that after parties are granted divorce, we don't want people dealing with one another. There must be a clean break principle. But now, in the event that you were, for instance, not employed and just contributing to the household by way of taking care of the children and making sure the home is warm when your spouse comes home, that is also a contribution. And you can make an application that, I need to be maintained. Obviously, there are certain requirements that need to be met. We look at your age, how old are you, and whether you're eligible for employment. Those things are taken into consideration. But you can make a successful application for maintenance to say, I need my husband or my wife to give me maintenance for this period, so as to allow me to get back on my feet, because now once I start my new life, it will be a completely different change. So I need sort of like a supporting system while I transition into a new lifestyle. Okay. So yes.
Okay. Interesting. All of this is like clean break principles. Guys, I'm hearing this for the first time. Where was I studying? Maybe I was not in class, but anyway. But this is so interesting and so informative. I thought we'd get into one that all Black people get into, guys: customary marriages. But what do? They write the letter, send it to the uncles, and then that Saturday somebody pitches. The uncles come in, and then there's like some negotiations. They talk, blah, 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 and then 1, 2, 3, they start eating. And then my mother starts ululating because, hey, my child is getting married.
Yes.
But is that marriage? So is lobola marriage?
Customary marriages are very interesting. It's a very interesting topic. When with customary marriages, whether it's valid or not, we are governed by the Recognition of Customary Marriages Act. It's what gives us the requirements on what makes a lawful customary marriage. So, first of all, in order for you to be in a customary marriage, you have to be 18 years and older, be able to give consent. In the event that you're younger, then obviously your parents need to give permission for you to get married. But the requirements are that you must be 18 years old and older, and you must consent to that marriage. And furthermore, that the marriage must be negotiated and celebrated according to relative custom that you practice. So those are the three requirements that we look at when we're dealing with customary marriage. So in the event that, yes, your spouse's families, they send a letter, and then they come and then they negotiate a bride price, if I should call it that, and then thereafter there's an agreement, and then we celebrate. Maybe we slaughter a cow or whatever people slaughter, and there's celebration. By virtue of the Recognition of Customary Marriages Act, that is a valid customary marriage. And the nice thing about the act is that it states that your marriage doesn't need to be registered at Home Affairs to be seen as valid. So even if it wasn't registered, it's still a valid customary marriage. Yes, it does help for you to get it registered thereafter, but even if it hasn't been, then you're still recognized as being married. And furthermore, okay, I almost lost my train of thought. So that's how it works with customary marriages.
Okay, so that means, let's say I met all those requirements, they saying I consented and vele meet the requirements that you just spoke about. Ngishadile, that means I'm married.
Yes.
That means there's legal consequences that's going to flow from that.
Indeed.
So what system applies to customary marriages?
With customary marriages, between two spouses, it's in community of property from the get-go. So meaning once you send your uncles, everything is celebrated and they take the bride, then you are in community of property. It's joint estate. Now we talk about a joint estate.
Patung. So let's say Mina, now, like many other people, they don't deem it as marriage. They still plan, they still intend to marry because umshadu is the white wedding and we sign, right? And I don't know that, now I am under the system, like I'm married in community of property. What can I do as somebody maybe who's still planning to marry to ensure that before we go through this process of negotiations and celebrations and entering into a customary marriage, I'm protected if I want to enter into a different marital system?
The nice thing about the Recognition of Customary Marriages Act is that it does allow spouses to enter into a civil marriage.
Okay.
So meaning that after you have paid, a lobola has been paid for you, then you decide that, we want to actually be married in terms of the Marriages Act. Then you can go and register a marriage and sign an antenuptial contract or go into it in community of property. That option is also available for you. But now the proviso is that both partners must not be married to any other person. So meaning that the husband in this instance must be married to only one wife, the wife that you paid lobola to. If there's a subsequent wife, then you cannot enter into a civil marriage. That's not how it works. It must be two spouses for that to happen. Because remember, with civil marriages, in terms of the Marriages Act, once you enter into it, you can't get married again.
Okay.
The door is shut.
Sure.
Yeah.
Okay.
So
So you must get a divorce if you want to get into a subsequent marriage.
Yes, then you have to get a divorce and then enter into a customary marriage. And also, if there's more than one wife, then there will need to be some sort of a marriage contract and antenuptial contract that will regulate the estate for both wives.
Yeah, I wanted us to explain that because now let's say we are married in terms of customary law, and then my husband pays lobola this year kagodi, and then he goes and pays lobola ka Sambo the next year, without my consent.
Yeah.
What does that mean? Am I protected in terms of the law as the first wife, or what rights do I have?
Well, it depends on the customs that you guys practice. I know that in many customs, the first wife must consent to the subsequent marriages in order for them to be valid. Okay. So in that instance, if you feel aggrieved, then you can approach the court to say, this marriage is not in terms of our custom based on A, B, and C, and then you can seek relief in that regard. But now, in the event that you do consent to the marriage, then the parties must go to court to say, okay, now it's more than one wife. Then the court will assist in drafting a contract, a nuptial contract that will regulate the estate. And what that does is that in the event of death, then we know that both families are catered for.
So it won't be in community of property for the three of us in the marriage.
That's not possible for that, because remember, in community of property, we're talking about a joint estate. Yeah. So meaning it's 50-50. So now we have to differentiate if percentage is 25, 55, 35 is not going to work. So it has to be out of community of property to make sure that everybody gets a fair share of the estate. Yeah.
Interesting. I don't know that. I was just going to be so upset. I'd be like, take all the money. As a third wife, I'd just be like, I'd leave me in peace. Take all the money.
No, people think like that.
But yeah, no, it makes sense. It makes sense. Thank you so much. And then you spoke about criminal law and contract and all the other stuff that you do at your firm. But I thought I was reading To Kill a Mockingbird this past month, and one of the characters there is an attorney, and he speaks of how there will always be one case in your life that's gonna change your life. And I thought, have you had one yet, or?
Wow. How old do you think I am?
I mean, maybe there's one that has moved you to tears.
Let me think. I deal a lot with family because I do practice in divorce laws. So I get moved when there are children involved because the children are so innocent, they are faultless. So, and especially when the parents are fighting, because as people say, when the elephants are fighting, the grass suffers. So you find that there was this case where the children were having a hard time. And because the parents were fighting, they could not come to an agreement. But through mediation, we managed to settle it and avoid a prolonged trial. And the children were able to keep both parents in their lives. So for me, any case that has to do with children, children are dear to my heart, then yeah, I would say those are the ones that stand out for me.
Awesome.
Yeah.
Awesome. And what's the longest time you've dealt with one matter, a divorce matter, for example?
The longest time I've done a divorce, I can say, now you want me to expose myself. The longest time that I've ever dealt with a divorce matter, I could say it's 2 years.
Okay.
2 years. I try to keep them within the 2-year mark. Okay. Because remember, we're dealing with people's lives.
Yes, true.
So now you cannot keep on dragging a matter for longer than 2 years. There's also expenses, children grow up. So I try to keep it within the 2-year mark to try and push it, within that reasonable time. Yeah.
Okay. So we discussed marital regimes and the implications thereof. But the other side of marriage is when your spouse dies. what are the legal implications there if my husband dies without a will?
Yes, as we know, in South Africa, a marriage can end by way of death and by way of divorce. So when a person dies without a will, we say that that person passed away interstate. And if a person passes away when they have a will, we say that person passed away interstate. So now, if a person passes away without a will, then it means that their estate is going to be administered in terms of the Administration of Estates Act. So when we administer the estate in terms of that act, then we look at beneficiaries of the bloodline, we look at descendants, we look at children and wives. So meaning that the people who will inherit from the deceased are the people that he is related to by blood. So that will be parents, children, sisters, and brothers. So it's like a tree, it goes down. We first start with the person, with the deceased. Was the deceased married? If he was married, then the spouse is entitled to a share. And depending on whether they were married in community of property or not, then that will also affect the division of the estate. Because if it was in community of property, then we have to divide the estate first, and then what the 50% that is remaining belong to the deceased is that one that will be administered in terms of the Administration of Estate Act. Then we'll look at the heirs. Does he have dependents? And if there are no dependents, then it will go up to the parents, and the parents will be able to inherit from that estate. If the parents are also predeceased, then we go down. Did the parents leave any children? Some call it issues. Then those children will inherit on behalf of the parents. So in this instance, it will mean that the siblings will be able to inherit from the person who passed away. So the main thing is we look at blood relation and also legal adoption, because you might find that maybe when he was married, for example, they got married and then they each came to the marriage with children outside of the marriage. Then in that instance, the child that belonged to the deceased will be able to inherit from that parent. However, the other child, unless they were legally adopted by the person who passed away, then they will not be able to inherit from that estate. But that's how it works with administration of estates. Yeah.
Interesting. So basically, if I die without a will, then the people who stand to inherit will be my family, whoever is bloodline, like you said.
Yes.
And if I die with a will, then I'm able to pick who I want to inherit, right? So I can leave it to Brian, Brian, my friend, or I can leave it to a cousin in the US and not necessarily my family. But let's say that I decide, right, to not leave anything for my children and my wife, and we were married out of community. Is there any protection in the law for that?
If the parties were married out of community of property, well, it would depend what kind of out of community of property. Is it without the accrual system or with the accrual system? You have to keep in mind that when you're drafting a will, you will be, if I should say, speaking from the grave, telling us what you want us to do with your assets while you're not here. So unfortunately, if there is no accrual system and it's a clean out of community of property without the accrual system, and you decide to leave your assets to someone else, then there's really not much that can be done. What can happen is that maybe the surviving spouse can have a claim for maintenance to their estate in the event that maybe they were not employed and they were staying at home. Then they can make a claim for maintenance to their estate so that they can be protected. Yes. Not even protected, but supported through that transition. Alternatively, if we look at a marriage out of community of property, including the accrual system, then if the party who is deceased had a higher accrual, then the surviving spouse, will have a claim for accrual on the estate. So those are the options that are available. Yeah.
Okay. So, and then minor children, they'd be able to also claim in an estate where, let's say, the husband died and did not leave them anything in terms of the will.
Unfortunately not.
Really?
Unfortunately not, because mind you, a will, it gives you discretion to do whatever you want.
Sure.
So if you decide that I'm not gonna leave anything to this particular person, then there's no other recourse that they may have, unless claiming for maintenance, that we are minors, we still need to go to school. So the state needs to support them in that regard. But for claiming for particular assets, then no, we can't do that because he has made his decision.
Okay.
You know.
So I guess then that is the consideration you must have when you are drafting a will, and I think that is something you should consider. If you have like minor children, are they covered in terms of your will, and your spouse covered in terms of your will? I also wanted to just find out from you, what are the benefits of having a will?
There's so many benefits of having a will. You know, if you don't like someone, you can just cut them off like ice. But when you draft, there are requirements when you're drafting a will. First of all, you must be 14 years and you must be able to understand the consequences of what you're doing. If you're not of sound mind, then you can't draft the will, because then we have cases whereby we don't know whether you knew what you were doing. So there's certain requirements that must be complied with when you're drafting a will. And as I stated, the nice thing about a will is that you can make sure that your family is protected. Because the problem with interstate succession is that sometimes it can get complicated with regards to assets. You know, family members after death, we tend to see people fighting amongst themselves. So now when there's a will, then they have to administer your estate according to your wishes. So in that case, it allows you to make sure that your family is protected, that your children are secured, and everything that you want to happen with your belongings is dealt with accordingly. So that's the best reason to have a will, you know.
Yeah, and you know, as Black people, we know the drama that comes after losing a parent or after losing a family member, you know. So I guess that is something we should consider, guys. As Black people, we really should consider getting ourselves wills. And I've heard about, is it a National Wills Week or is it just Wills Week?
Yeah, it's a national wills. Oh my gosh, tongue twister. It's a National Wills Week, and it's going to be starting from the 13th of September up until the 17th of September. During that week, you can actually approach the Law Society of South Africa, and they can give you the name of a law firm that is nearby. And then you can go there and have them draft a will for you free of charge.
Oh, awesome. Yeah. I think this is a great initiative. I mean, like we always say, justice is for everyone. We often speak about how we want everyone to have this access to justice, and this Wills Week really gives people the opportunity to have some form of access to that. In terms of drafting their wills. I think this brings us to the end of our conversation. Thank you so much. I've learned so much today from custody of children and into the different marital regimes that apply in South Africa, as well as customary marriages, which is, I think, very important because Black people, you have no choice, guys. Like, lobola, unless if you decide otherwise and you have that, you know, you're that kind of girl who can stand your ground and say, you know what, mommy, it's not coming into this house, that thing is not applying here, you know. So I think that was very educational and insightful for us. And we got into wills as well, and we learned about the Wills Week. Please, guys, if you have enough assets to go and have your will drafted, approach the Law Society and find out which firms are drafting wills for free during that period. Yeah, I think it was very legal today, and I really appreciate you. It's going to help somebody, any student who is interested in practicing, I think, family and estates in the future. Thank you guys for watching, and goodbye.
Bye.